$529 billion. That's billion with a B. As of 2022, that's how much the tort system costs the U.S. economy every year. That's according to the U.S. Chamber of Commerce Institute for Legal Reform. That's over $4,200 per U.S. household. But we're starting to see this number come down, and that's what we're going to be talking about today. Welcome to the Future of Risk, presented by Zurich North America. We explore the changing risk and resilience landscape and share insights on the challenges that face businesses to help you meet tomorrow prepared. We're kicking off this year with our new podcast mini-series focusing on social inflation. The term social inflation refers to the rising costs of insurance claims and litigation expense beyond general economic inflation. These costs are driven by societal factors rather than traditional market forces. Those things contributing to these rising costs include social attitudes, legal practices, legal system abuse, and cultural norms. Now, the impact goes beyond the insurance industry. In addition to higher insurance premiums for businesses, it also puts a strain on the economy and added to growing financial pressures on everyday consumers. Today, in our first episode, we'll take a deeper look at the legislative outlook across the U.S. and its broader impact. I'm Al Orendorff, and today I'm speaking with Deirdre Manna, Head of Government and Regulatory Relations at Zurich North America, and Adam Shores, Senior Vice President, State Government Relations at the American Property Casualty Insurance Association. Deirdre and Adam, welcome to the podcast.
Thanks, Al. Great to be here.
Thanks, Al.
Great to have you. This podcast series is about the larger issue of social inflation, but legal system abuse is a contributor. Deirdre, can you define legal system abuse, what it is, and how do we get here?
Thanks, Al. That's a great way to kick this off. I think that a lot of people don't really understand what it is exactly. And how do we define that? How do we define legal system abuse? And basically what is taking place is that we're seeing larger settlement and payouts and jury verdicts placed on our customers and companies to the plaintiffs. So we'll see a lawsuit and it can either be arbitrated or it can be considered by a jury or it can be a settlement negotiation. And what we're seeing is the payments that come out are growing and growing and growing. And why is that? There's a lot of reasons why, and we define it as legal system abuse. There are a lot of state laws and judicial rules and elections, plaintiff attorney tactics. These are all items that are inflating legal awards. So when you look at what happened in the 90s, how did we get here? There was a lot of laws passed. We called that at the time tort reform. Now we refer to it more as legal system abuse, but we had a lot of reforms in the 90s. They have all been eroded. So what we've seen is a continual increase. How did they get eroded? The states passed new laws. The juries started considering larger verdicts for plaintiffs. There were elections where pro-plaintiff lawmakers were elected and they passed laws that really were unfair to one side. So we've seen this erosion. We've also seen a general society trend, David versus Goliath, where corporations are considered Goliath and juries and judges are very sympathetic to David, and therefore they tend to award the plaintiffs more. We think victims should be paid what they are owed. But what we've seen is this inflation, these really large judgments going out against companies. And what that leads to is exactly the stats that you talked about at the beginning, Al, where it's costing all of us. People don't understand that this isn't free, that these awards cost everyday people. I like the stat you used of $4,200 per household. But, there's no silver bullet. So the reforms that we're talking about aren't, there's nothing at the federal level. There's a few things at the federal level, I should say, but most of it's a state by state game. It's a long-term game. And so that's what we're looking at to combat legal system abuse.
You can't look at any one thing as the reason for this. And so you're not going to be able to look at any one thing as the solution for this issue, correct?
Correct. That's exactly right.
Adam, what are your thoughts about some of the pressures that have led to this place where we are right now?
Yeah, well, thanks for the question, Al. And I guess when we talk about legal system abuse, the one word that, of course, stands out to me in that is the word abuse. And that's really what's adding to these cost pressures for consumers, for businesses, is the just unadulterated gaming of the legal system and the abuse of the legal system by the trial bar, by financial investors who are seeking to stack the deck in a way that presents unfairness for consumers, that presents more cost pressure, especially when we're in a time of heightened inflation overall. Gas costs more, groceries cost more, houses are more expensive if you can even find them, cars cost more. So all of those pressures are there already, and consumers and businesses are dealing with those issues. But then when you inject an abusive dynamic in the American legal system, whereby the desire to sort of add to financial awards or windfalls or look at that as a way to have a payout on the backs of businesses and the backs of consumers, that cost goes up for everybody. And Al, you mentioned it. You talked about that average $4,300 per household cost. We call that the tort tax. That number fluctuates from state to state, but overall, when families sitting around the kitchen table are having to look at, how to balance their budget, they now have to factor in those rising costs, what that means for them. So, and how does that really play out? If a company is sued by a plaintiff and an award or a judgment comes back against them, when those pile up over time, that just adds to the bottom line cost pressures for companies, and that gets then translated down to consumers. And that's where that cost or that tort tax comes into play. And that's the real effect of what we see here, is at a time when people are struggling financially as it is, to have that challenge exacerbate that presents an even stronger difficulty for people.
Deirdre, you had mentioned briefly in our opening discussion about one of the things that was driving this is plaintiff's attorney trial tactics. I think that's worth a second look. What are some of the things that plaintiffs' attorneys do that have exacerbated this issue?
Yeah, this is a question that we could spend the entire podcast on. So there's about 10 top issues, I would say. So let me just break down a few of them. I'll break down 3 of them: venue shopping, third-party litigation funding, and phantom damages. First, on venue shopping, which is a common practice among trial lawyers. What they do is they pick the venue that is going to be most favorable to them for the outcome, where there's a lot of legal system abuse. In fact, the American Tort Reform Association just came out with their list of what APCIA has termed judicial hellholes. And what they did is they identified 10 areas that are very favorable to plaintiffs and very unfavorable to defendants. And what happens is trial lawyers use venue shopping. So they don't go to the venue where the tort happened or where the accident took place or where the plaintiffs are or where the defense is. They go and they shop and they find the best area for them to try their case. For example, the top judicial hellhole for this year identified by APCIA is Philadelphia Court of Common Pleas and the Pennsylvania Supreme Court. That gives you an example. You'll see an overload of the court in that state and in that area because it is more favorable. The second area that I'll mention is third-party litigation funding. And that is where we see hedge funds financing litigation. So it's third parties who do not have any role in the actual case itself. So they weren't injured, they aren't defending, they are just have money and they're funding the litigation. And then what they do is they hold out for the highest amount and they take part of it back for themselves. And we've seen some of these third-party litigation funders take back 95% of the settlement, meaning the plaintiff gets a very small amount. We've even had cases where the plaintiff has gotten 0 and the litigation funding firm gets the entire amount. The last one I'll just mention is phantom damages, which is very popular as well. To define it, it exists anytime lawsuit recoveries are calculated using the dollar amount a patient was billed for a medical service versus the amount that their insurer, Medicaid, Medicare, or work comp actually paid for the treatment. So those are just three examples of some of the tactics that are used. And we're going to get more into like what we're doing about to counter those later.
As you mentioned earlier, this problem exists, this issue exists on multiple levels. So that is probably one of the things that makes it a challenge to combat, I would think. Adam, speaking of complexities, this is something that might be difficult for some folks to get their head around. How do we position this issue in such a way that people can care?
Great question. I think you have to do that both at the macro level and talk about what the overall impact of this problem is on the American economy, what the impact is on individual state economies. But then, as I spoke to earlier, what does this mean for individual business owners who are trying to make ends meet, who are trying to grow and advance? What does it mean then for individual consumers who are trying to make a living and care for and protect their family? And I think just some of the key numbers that kind of stand out that really underscore what sort of challenge this is, and some of these are kind of in the abstract when you think about the billions of dollars, but when you look at how the current abusive practices in the legal system have really framed the cost for the overall economy. Just a couple of points. The U.S. corporate legal spending on class actions is projected to be about $4 billion this year. That's billion with a B. And Deirdre mentioned the rise in nuclear verdicts and some of those issues. We see that just continuing to grow and grow. When you look at the top 100 verdicts in the country, they've increased about 350%. From an average of about $64 million 6 years ago to an average now of about $225 million. So that's just an incredible amount of cost that is added to the system. And then when you look more at the individual case level, and this I think goes back to 2020, but the median personal injury judgment about 10 years ago was about $49,000. And today it's about $125,000, or in 2020 is about $125,000. So those, are real world examples. Those are real dollars that we're seeing. And then what adds to that, and we haven't really talked about this yet, is what happens outside of the courtroom, which is the practice of attorney advertising, where the trial bar sort of positions itself as the champion of consumers. And we all see the billboards, we all see the commercials on TV. I mean, they're nonstop. They're incessant. In fact, I was joking earlier, it's like, can we just continue the election so that we can see less trial bar advertisements and more political advertisements? So it really underscores, the problem that we have there. And if you look at the rise in attorney advertising, a few years ago, I think that number sketched out to be about $1.4 billion spent by attorneys on advertising. And that's investment that they're going to take every time. They're going to put money into that because they know they're going to get billions and billions out of it. And we've got to shed some light on that as well and really put the position back on them and underscore what's their motivation. Deirdre talked about third-party litigation funding. Those financiers, they are solely involved in that process for their own financial benefit. They purport to be there to support those who maybe can't file a suit and can't afford to go through that process at trial. They purport to help them, but they're really helping themselves. And we see that with the trial attorneys themselves as well. They're advertising that they're going to be out there fighting for the consumers. Well, they're not completely altruistic. They're fighting for their own financial well-being as well.
I understand that both Zurich and the APCIA are important players in a multi-industry coalition that is actively involved in efforts to change some state laws that make it hard to combat some of the abusive practices. How did this coalition come about?
Well, I'll kick this off, Adam, and then turn it over to you. But
sure.
Basically what happened was the industry in and around 2019 started to kind of take a look at what we can do to these rising costs, what we can do about social inflation and legal system abuse. And as we were seeing our customers having to pay more for their rates. So we started around that time, and then COVID hit. And then we had to really turn our focus. There was a lot of bad legislation, a lot of harmful proposals and legislation and regulations that were coming out during COVID. And so we turned our focus to that. Well, once that kind of died down, we went back to it. And Zurich started the coalition. What we did is we started a claims organization because a lot of these problems are with the claims. And it was the first time anybody had really done that. They taken their claims operation and kind of moved them in with the advocacy part of the GRR part. So we started that division at Zurich. And then we started to build the coalition with our competitors, with our customers, and with our brokers, something that had never happened before. This type of coalition where we weren't doing it on our own. We weren't doing it with some of the groups that have been out there for years, ATRA and ILR, the Institute for Legal Review. And we partnered with APCIA as well. And they took it as their priority issue. So we started reaching out to brokers and customers, and we started to educate this coalition to say, here's the problem. Then we started to determine, along with our partners, including APCIA, where do we need to focus? And I think that's an important part of it because, as I said earlier, there's no silver bullet. There's not one law at the federal that we can practice that's going to take care of legal system abuse. It's a state by state. It's also a long-term game. And that's what everybody had to understand, is that this isn't going to happen overnight. We need to build the coalition, tell our story, pass legislation, change regulations, and also look at what's going on in the courts with the court rules. So it's a very complicated strategy, but the coalition has grown tremendously. Every major insurance carrier is involved. All the major corporate Fortune 100 companies are either aware of it, are working on it, or have either joined. And then what we've done is we've done a symposium every year, an in-person one. The first one was held at Zurich, where we brought everybody in the room. And then we've also do 2 virtual, but we constantly communicate with this coalition when there's a bill out there, when there's action that they can take to help us address these issues.
Sounds like the coalition's very existence, kind of underscores the point that you made earlier that more and more people, more and more organizations are seeing this as the problem that it is.
Exactly. We have, like I said, it's been tremendous support and interest and activity by this coalition in terms of addressing legal system abuse.
Now, Adam, are there certain states that we're focusing on?
Yes, in fact, there are, Al. And let me just say, this is the signature issue for APCIA and our members. And we're so proud to represent Zurich and partner with Zurich in that regard, along with the rest of our member companies who also equally see the challenges and feel those challenges with this and have invested time, money, effort, resource, not only among themselves, but to Deirdre's point, extending that network to your clients and your customers and the businesses that you work with, because they all have resources, they're all feeling this, they've all got assets that can help tell this broad story. And so we have built out a priority strategy plan for the last couple of years to identify about a dozen or so key states where we really have identified opportunity areas for us to move the needle in a positive direction. And many of those states are those judicial hellholes that Deirdre mentioned. And we're continuing that work in 2025 as well, where we've again identified, top 12 or so states where we're focusing a lot of effort to either build on reforms that have already started or to entertain new opportunities with new legislators and new policymakers to talk about things. And so some of those key states that come to mind are Georgia, Louisiana, Texas, Nevada, Florida, where we built a number of successful reforms 2 years ago, thanks in large part to that coalition effort that Deirdre was talking about, where we engaged business community leaders, the entire insurance industry, around establishing some very meaningful reforms. But now we know in Florida we have to defend those reforms because the political tide has shifted a little bit, where the